The Honourable Susan Carter.
Mr President, I lead for the opposition on this bill. The preamble of the Bail Act sets out the difficult job facing courts when considering the grant of bail. Every bail decision must ensure the safety of victims of crime, of individuals and of the community as a whole, and this requirement for safety is paramount. Those considering bail are also required to ensure the integrity of the justice system. Our justice system is more fragile than it can appear. It is often a fine line between relying on our system to achieve justice or seeking personal retribution. Continuing confidence in our system of justice is an important public good. And of course, every bail decision is made post-arrest, not post-trial. We may suspect that the accused is guilty, but we do not know this, and as a protection for us all, we presume innocence until such time as guilt has been proven. One way, which has been operating successfully for well over 10 years now, of balancing the presumption of innocence with the need for both continuing community safety and the perception of a just system which ensures community safety, has been the use of electronic monitoring of those on bail. Electronic monitoring allows those who we presume to be innocent to continue to work, pay the mortgage or the rent, provide for their families, but also track their movements and restrict them from going to certain places to ensure community safety. This will not be an appropriate protection for every accused, but where it is appropriate, has proven to be an effective way of managing safety and liberty. So effective that this government has recently legislated to extend this program to those granted bail after being accused of serious domestic violence offences. When considering questions of bail, courts are directed to consider, among other matters, the likely time the accused may spend in jail, on remand before facing trial. The Chief Justice of New South Wales has recently indicated that this may be a significant period of time and that a person charged with a serious offence may have to wait up to 3 years before their trial comes on for hearing. This is a particularly lengthy period if the person is subsequently found to be innocent. Electronic monitoring has been recognised as an effective method of managing community safety, but also liberty. There are currently 2 kinds of electronic monitoring in the New South Wales justice system: public electronic monitoring and private. The first electronic monitoring for bail was privately provided electronic monitoring, ordered by the court as a condition of bail, used as long ago in 2010 in Crown and Medici. In the case of Crown and Ebrahimi, Justice Beach Jones, then of the New South Wales Supreme Court, now of the High Court of Australia, accepted, quote, that the electronic monitoring proposal mitigated the risk of the accused absconding, but did not eliminate it, end quote, and subsequently ordered its use, accompanied by a number of conditions. The coalition government introduced regulations in 2021 which dealt with the minimum technical requirements for private electronic monitoring devices to provide a level of statutory quality control over the minimum standards that will be required when a court ordered electronic monitoring as a condition of bail. But under this bill, the implied right of a court to accept and order private electronic monitoring as a condition of bail, the kind of order that courts have been making in New South Wales for well over a decade, will be taken away. The new Section 30A in Clause 6 of Schedule 1 of this bill will replace the existing Section 30A, which currently sets out those minimum requirements which are to be met if bail is granted on a condition requiring electronic monitoring. The new Section 30A, which this bill will introduce, provides as follows. A bail condition must not require an accused person to be subject to electronic monitoring other than a bail condition imposed under Section 28B. Section 28B contains the provisions that were introduced last year requiring electronic monitoring for bail granted for the offences referred to in Section 16B, 1C1 of the Bail Act, which of course are those serious domestic violence offences which have already been referred to. So, following this bill, the only accused who will have access to electronic monitoring in New South Wales as a condition of their bail are those accused of serious domestic violence offences. and this is electronic monitoring in respect of which the community will meet the full cost. It is not clear that this is the best policy setting, and it is disappointing that the government blocked the opportunity for this House to consider this measure carefully through a committee. To repeat, one of the objectives of bail is to ensure the integrity of the justice system, making considered, informed decisions rather than knee-jerk responses is one of the clearest ways to maintain this integrity and ensuing public confidence. The abolition of all private electronic monitoring in New South Wales, which this bill will achieve, appears to be a knee-jerk response to issues with one provider. In early 2025, BailSafe, a company which had been providing private monitoring of persons on bail in New South Wales and Victoria, ceased their operations. At the time, the company's major business was in Victoria, but there were some 25 persons in New South Wales who were being monitored by them. After the failure of BailSafe, the New South Wales persons who were being monitored were transferred to another private provider, Allied Universal, the subsidiary of a large group operating in 36 countries, monitoring in the order of 150,000 persons daily. Since 2013, Allied Universal has performed monitoring in New South Wales and Victoria, operating since 2000 in South Australia and since 2018 in Western Australia. In New South Wales, Allied Universal is currently the only private provider with about 126 persons currently monitored on a variety of offences. That electronic monitoring provided by Allied Universal appears to be working without reports of any incidents or any problems. Victoria, of course, also had BailSafe as a provider, and they faced the same issues with that private bail provider as we did in New South Wales. But rather than rush to legislate to abolish all private providers, they established an inquiry in February this year to assess, in respect of each person, the circumstance that led to them having a condition of bail imposed that they were subject to private electronic monitoring, whether after the collapse of BailSafe, unacceptable risks and community safety had been properly managed, and to consider whether it was necessary to legislate to end the private provision of electronic monitoring for people on bail. It is a very rare occasion on which I suggest to this House that Victoria has a preferable method of dealing with a policy issue than New South Wales. Given that the likely consequence of this bill is to allow some people to be granted bail without protecting the community with electronic monitoring, the New South Wales Government should have investigated whether it was possible to better regulate private electronic monitoring companies, as occurs in many countries, rather than rush to impose an outright ban, as this legislation seeks to do. An upper house inquiry could have investigated the type and adequacy of potential future regulation over private providers, drawing upon the experience in other jurisdictions. But that inquiry will not proceed. The inquiry could also have investigated whether public electronic monitoring is different to, inferior to, or superior to private electronic monitoring, and whether it is more protective of the community if a person is granted bail. It could also have considered whether public electronic monitoring should be made available to more accused than just those on bail for serious domestic violence offenders. This legislation has the curious effect of privileging such offenders, surely an unintended result. An inquiry could also have considered what additional resources the justice system may now require that private electronic monitoring is no longer available. The Chief Justice has recently highlighted the finite resources in the criminal justice system, which lead to a lengthy trial delay. These include the number of judges, prosecutors and public defenders, as well as the limited number of courtrooms in which jury trials may be held. Without private electronic monitoring, the bail choice is now either unmonitored, with subsequent risks for the community, or remand. A remand which, because of the constrained resources of the criminal justice system, may be lengthy. What work is this government doing to better resource this sector, consequent upon this decision? An inquiry could have made important recommendations in this regard. The Coalition supports the use of electronic monitoring in the youth justice context. We have seen it work well in other jurisdictions. Electronic monitoring can be a very efficient tool to enforce curfews and geographic restrictions. An inquiry could have paved the way for its introduction in New South Wales, especially in areas of high youth recidivist crime. But sadly, this opportunity has been lost. It appears that this government does not want to truly consider how to strengthen the justice system and make our community safer. It just wants to quickly respond to spot fires and then just as quickly move on. This is deeply disappointing. The opposition cannot block this legislation, and we never wish to be obstructive in matters of criminal justice. But we do wish to record our disappointment that this House and this government, by blocking the inquiry, has missed an opportunity to further investigate the benefits of electronic monitoring to support community safety and prevent repeat offending in our justice system. And I conclude by reference to the Boxar Report number 255 of May 2023, which in the context of parole and following an assessment of a large cohort of cases with a robust control group, found that electronic monitoring reduced domestic violence reoffending by 33%. Surely an argument for expansion rather than the contraction which this bill represents.
Mr. President.